In a slightly more unusual way, today we have a little bit more of an interdisciplinary approach, in that we are now looking at the design of regulation for corporate human rights impacts in various member states of Europe, and also at European level, and also in other jurisdictions of the world. And in this process, it is important to consider what effective regulation would look like in this space, and how that can be achieved, and in what way the legal practitioners and even companies that are advised by our members could participate in designing a mechanism that is effective. So when we talk about effectiveness, also there are different ways of defining effectiveness in a way that the first level would presumably be compliance. So if you look at the reporting requirements, a report would presumably be a compliance with the law. But there's also taking it a bit further in terms of understanding effectiveness is the way it drives corporate behavior, so irrespective of the compliance. And then the third leg of effectiveness, which we have discussed internally amongst some of our speakers today, is effectiveness in actually preventing human rights abuses, and whether it's even possible to ever measure that. So with that background in mind, I would now like to hand over first to Charlotte Michon, who has done extensive research on the French Duty of Vigilance Act and the implementation thereof, and has some thoughts on how to measure the effectiveness of a law such as this, which is still very new, but has potentially quite important impacts. So Charlotte, I will hand over to you. Thank you so much for being here today.
Yes, good morning. You can hear me? It's good? Okay, good morning, everyone. So many thanks to Liz and Claire and Irene for the invitation today. Just before I start, I would like to apologize if my English is not good or not clear. I'm only working with French company and corporate departments in France. And so, to be honest, I don't practice English every day. So please don't hesitate to ask me for explanation, and if needed, I will call on the help of my French-speaking colleagues, as Claire. So I'm the executive officer of an association, Entreprises pour les droits de l'homme in French, which means Businesses for Human Rights. And so we are today 19 French companies, large French companies from different sectors. And we have been working for more than 10 years now on human rights vigilance approaches as defined by the UNGPs and now by the French Duty of Vigilance law, because all our members are concerned by the law. And we also consider that the French law is the transition of the UNGPs. The law, we can say that today we are in a particular time, because the law was adopted 3 years ago now, but we still have no case law, we still have no judgments, and practices of companies, to be honest, are very diverse. And on the other hand, the expectation of NGOs and trade unions are very, very strong. And so it's difficult today to be certain about the law, and the interpretation of the law can differ and differs according to the different actors. So what I'm going to tell you, it's some reflection on practitioners' reflection on effectiveness of the law and human rights approach regarding the practices of companies. The first things I would like to say is that today, clearly, we cannot rely on reporting to measure the effectiveness of the French law. So it's true that the French law does not aim to create just an obligation of reporting, but rather an obligation to do, an obligation to establish, to implement a vigilance plan. And with the French law, the reporting is finally the means given to the stakeholders of the company to verify the obligation to do. But clearly, what we can see is that the reporting of companies does not make it possible to know if the law is effective, because the reporting does not make it possible to know the reality of the human rights approaches in companies. And there is a big gap between what is done and what is said in annual reports, even in advanced companies. The second preliminary thing I want I would like to tell about this law is that it is a framework law. It only contains 2 sections, and we don't have a government directive on the, or as I said, we don't have judgment at the moment to help us to interpret the law. And so companies are finally free to give their own interpretation, and they have a large margin of appreciation to implement the law. And what we see in some companies, companies that did not know the subject of human rights or corporate responsibility to respect human rights, is that these companies adopt simple compliance approaches that clearly don't address the subject. The law requires 5 steps for the vigilance plan, which are with mapping, action plan, regular assessment, ethical alert mechanism, and monitoring systems. And companies can adopt a tick-the-box approaches and have finally compliant processes in place on paper without respecting human rights in practice. And we see that in some companies. So how we can measure the real effectiveness of the law and of vigilance approach, and finally how to measure, I think, and it's the key, the understanding of the spirit of the law, which is of course to protect people and the environment, and also to give access to victims. I think we can already try to measure whether the company has understood the law and whether it has integrated human rights reflexes. The first things is to see, from my point of view, is to see if the company wants to identify and manage risks on people and not risks for the company. And when we read the vigilance plans today, in many cases, the notion of risks is not clear, of human rights risks is not clear. Even so, risk mapping is the first step, but also the fundamental step for the effectiveness of the whole processes. And companies have not necessarily understood the notion of human rights risks, and some confuse them with corporate risk, but also with extra financial risks. Still, concerning the risks and their understanding, I think it's also possible to see the company's willingness to decline its risks at the operational level, and its understanding that human rights risks can only be assessed effectively at the local level. And of course, another human rights reflex is that we can look at to measure the effectiveness of the approach is the company's ability and willingness to listen and to take into account the expectations of stakeholders, of course. In addition to these human rights reflexes, I also believe that the effectiveness of the law can be measured in relation to the importance that the company give to it, and finally to with internal changes within the company. What we see since the adoption of the law is that companies that were already advanced in human rights approaches because there were challenges by their stakeholders. But these companies have used the law to re-examine their practices and to progress. And we can see that with the systematization of risk identification and management processes in all the company activities. Often these companies managed a certain issue or activity, but because they had been challenged on this issue. And the law allows them to formalize processes and to systematize risk identification. And we see more and more companies integrating human rights into global ethical compliance processes, for example, ethical due diligence on partners, in internal control to monitor, but also assessment of human rights criteria before any new activity. And so I think finally the law will be effective if the company shows and understands their need to integrate human rights into all global processes and to cover all activity of the group. I also think that, and I will finish with that, the company's willingness to control, to monitor the application of its vigilance plan and its approach, and to measure the performance of the plan can be a guarantee of the effectiveness of the law. And to be honest, there were still very few indicators in vigilance plans, even this year after 3 years of application of the law. And often they are the ones that existed before the law, because all companies had a previous CSR approaches with indicators. But these indicators are not yet risk-based indicators or measure performance indicators. They are indicators often on the deployment of the measures. And companies are not yet questioning the performance assessment, but we know that it's very complicated when we speak about human rights issue. But I think until we measure performance measure, I think we cannot know if the approach is fully effective. And so I think that measurement performance can prove a high maturity in the human rights approach, and so its effectiveness. So I finished. So thank you. And if you have questions.
Thank you. That was really, really interesting. And I think we will have some questions at the end that I think all the speakers could respond to together. But thank you so much for that, Charlotte. Very interesting. So now I'm going to hand over to Lisa Histon and Steve New at, we're working together with them at the Oxford Bonavero Institute of Human Rights. And I suppose, Lisa, maybe you might introduce just a little bit about that study that we're working on together, but then also your thoughts on the topic. Thank you so much. I'll hand over to you now.
Thank you so much, Lise. Good morning, everyone. So thank you again to Lisa and Edini and Claire as well for inviting us to this roundtable. Just so by way of introduction, this presentation is based very much on an ongoing project between the University of Oxford, where Steve and I are based, and Lisa and Edini at the British Institute of International and Comparative Law. So the project has been funded by the new Modern Slavery Policy and Evidence Centre, which was set up towards the end of last year following the independent review of the Modern Slavery Act. The project is very much precisely focused on the topic of this roundtable today, and we wanted to just share with you some of our initial findings and thoughts. So I'll speak briefly on how effectiveness might be defined before moving on to talk about some of the ways that effectiveness has been measured so far. Before then handing over to Steve, who will take a deep dive into One Babcock International to illustrate some of the points that we want to make. And I haven't shared my screen yet, which I will do in a moment. But before we start, I actually just wanted to acknowledge that modern slavery as a label does have the potential to deflect attention away from historical slavery. And I think given what we're seeing on the world stage at the moment, we here are using the term very strictly in terms of the Act, and we're focusing on the reporting requirement for businesses in Section 54 only, not the rest of the Act, which I think actually should be looked at as perhaps a broader study on effectiveness. But for now, we just look at Section 54. So let me share my screen with you now. Just bear with me for a moment. Right, does that come up on everyone's screen? So if you would like to, I understand that there's a function on the top of your screen where you can choose to see the slide and the speaker side by side. So if that's an option you want to take, feel free to do that. So first, okay, what does it mean for the Modern Slavery Act to be effective? So I think most people would probably agree that Section 54's effects in the UK to date have been characterised rather negatively. We know from the Modern Slavery Registry database run by the Business and Human Rights Resource Centre that there's about 17,000 companies that have reported so far or published statements. But what we don't actually know is the total number of companies that are supposed to comply with the provision. And so although the Home Office has written privately to some, out of these 17,000 something companies, we understand that only 29% actually fulfill the basic compliance requirements. So Lisa's already mentioned this briefly, but the basic compliance requirement is really only one level of compliance, and there are others. So in the 5 years that the Modern Slavery Act has been enforced, we see effectiveness defined in three main ways. One is the very basic level compliance, which means you can publish a statement that says you're taking no action on modern slavery at all. That's entirely possible. Or you can reach the compliance level of actually creating some sort of internal change or improvement in the corporate behaviour, something that we hear anecdotally about quite often when we speak to people who are directly involved on these issues. And then we also have finally the effectiveness at preventing or eliminating instances of modern slavery, which is obviously the ideal. I would add at this point that effectiveness can also be defined in terms of how well the provision has actually performed against the designed expectations. So here we've got some of them on the slide. I would say, for example, the scope of the Act was limited to large companies because it was meant to have a trickle-down effect to the suppliers further down the line. The annual reporting requirement was designed to ensure or encourage year-on-year improvement. We also have some companies that wanted legislation in place to encourage a levelling of the playing field. We have civil society that thought reporting would encourage self-reflection as well as a race to the top between companies. And we also have government who thought all of this could be monitored by civil society and enforced by the market, and in the form of consumer pressure by requiring the statement to be published on the home pages of corporate websites. Now, it should be noted that Section 54 is really quite a unique piece of regulation. There is nothing quite like it. And we see this very much through Lisa and Irini's in-depth comparison of Section 54 with other reporting requirements, which features as part of a huge part of our project. But there's been now persistent criticism that companies are not doing enough. Even companies who are keen to do the right thing 5 years on are starting to feel somewhat disillusioned. And civil society now refer very much to the state of modern slavery compliance as a race to the middle rather than a race to the top. So given that there is a verdict out there on Section 54 already, Steve and I thought, well, we decided that we should examine this verdict in a little bit more detail and look at exactly how effectiveness has been measured so far.
Sorry, Lisa, I don't want to interrupt you. I just want to check, the microphone seems to be coming and going a little bit. If you could maybe speak a bit closer to it, sorry.
Okay, right. Sorry about that. Hopefully you managed to catch most of what I had to say earlier. So if we're looking at measuring effectiveness and looking at this verdict that is currently out there already, Civil society reports like the FTSE 100 report by the Business and Human Rights Resource Centre aren't the only secondary material available. We recognise that there are benchmarkers, academic reports, exposés, as well as press reports, and it may be the case that we then go on to look at these other sources as we carry on with the project. But the reason we wanted to focus first on free and publicly available civil society reports to begin with is largely because they were the designated monitors of the Modern Slavery Act. In fact, during the parliamentary process, the government said it believes that it is for civil society to put pressure on businesses that are not doing enough, and the provision has been designed to make this as easy as possible by ensuring that disclosures are easily accessible. And what we have found is that the government has not made it as easy as possible, and civil society are really struggling. They're struggling to review more than 200 statements for their reports, and other sample sizes that we have seen are really far too small to actually be representative. Only 2 organisations have produced year-on-year assessments, and actually there is a real lack of detail in all of these reports. That's not a criticism on civil society per se, but we want to be able to show that actually that there is very little impact being created. So impact is fairly minimal, and actually the impact is quite circular in our impact assessment. The reviews in these reports are also quite basic narratives commenting on how little information is provided, and we think they actually perform more as instruments of advocacy rather than monitoring. And so here I will actually want to hand over to Steve to discuss how a review could be conducted, which reveals just the level of knowledge, time, and resource that is needed to do this type of exercise properly. So let me actually stop sharing the screen for now. I'll bring it back up when I return to sum everything up. But Steve, over to you, if that's all right.
Okay, thank you very much, Lisa. As Lisa explained, one of the puzzles about the MSA is the extent to which it functions in collaboration or in concert with the work of civil society. We can have a discussion about what exactly we mean by civil society, but how that functions. And so one of the things we wanted to look at was some case where a company had produced a report, and that report had been deemed to be not very good, and so the company had then responded to things. And one of the interesting things is those cases where a particular firm's report is savaged by somebody is very rare indeed. And in fact, I think I'm right in saying, and you know, this is a kind of a statement which could always be proven wrong empirically, but I think I'm right. So basically, there's only one company that's been featured in the pages of a UK national newspaper for having a bad modern slavery statement. And this is a company called Babcock International, which you probably never heard of. And it's a company which was there because in the one of the first reviews by the Business and Human Rights Centre of modern slavery statements, it just happened to be one of the companies that was chosen to be looked at, and it happened to come bottom. And that coming bottom in the list of the sample of companies happened to be picked up by an FT journalist, and so it featured in a story saying that, you know, this is a company who produced a rubbish report. So we thought it was interesting to go and look at that company in a bit more detail and use that as an opportunity to reflect on how the MSA process of scrutiny and civil society action is supposed to work. And a few interesting things come out. I'm not sure, you know, obviously if you're just looking at one company, there's a problem with building too much on that particular case, but it's still worth nevertheless exploring. So Babcock International is a company, it's quite a large company. It's got 5 billion turnover, that sort of figure, 35,000 employees. So it's quite a large firm, and it works in basically the defence sector. So basically it's a defence contractor for the UK government mostly. It works for other governments around the world, and it does things like supporting UK's nuclear submarine fleet, maintaining shipyards. In fact, doing a bit contribution towards the building of military ships, providing vehicle support for the United Kingdom Army, that sort of thing. So it's That's the kind of thing it does. So it has no consumers. So there's no exposure to customers. It's not like a firm like Procter & Gamble or Nestle, where people have heard of it or engaged with it or would boycott it because it's, you know, essentially an invisible company. It's also an extraordinarily complicated company. And one of the interesting things when you start looking at its organizational structure is there are hundreds and really hundreds of firms, all with very slightly similar different names, different locations. And some of them get included under the orbit of the MSA statement that's published by the central group. But many of them don't. And that's because Babcock have decided that those subsidiary companies, which are wholly owned subsidiaries in most part, which themselves, where the business unit exceeds the MSA threshold, well, they'll include those under the group reporting. But others, which fall a bit below, it's decided not to. So it opens the prospect, of course, there should be activities which are not being reported on. But that's basically an accounting choice by Babcock. That's how they've chosen to structure their affairs. Now, one of the things that happened when the first report came out some years ago was that the report that was initially published was very similar to many other firms' report. It was pretty sort of shallow, very short, no detail whatsoever, lots of things missing, wasn't signed by a director, wasn't dated, didn't have some of the information that the Act required. And progressively over time, you can see the statement has filled out, and it's become a much more comprehensive document. And indeed, it's complemented by a load of other stuff about their policies in other activities and relationships with their supply chain, which they publish. But the thing is once you do a detailed analysis and see how it's moved past, mostly you can see the changes are not really substantive. So although the reports now are more fulsome and they look much more like the reports which get better ratings when people do the rankings of statements, it still doesn't really tell you anything at all about either Babcock's supply chain or any actions they're taking or really any of the risks they're holding. In fact, they stick to a line that says, we don't think we have any risks in our supply chain at all, and that's just it. There's no way you can penetrate that. So this is quite interesting. The other thing which is interesting to note is although the over the years, over the 4 versions of this report we studied in detail, you can see very substantial lengthening of the report, and there's more words, and the words are more polished. Presumably they've hired, extensive amounts of consultants who've come in to draft this thing for them. The change and the substance of the report is no different to what's happened to other similar companies. So I don't think it's possible to draw any conclusion about the fact that it was featured in the FT and that's caused changes in how they've done MSA reporting, because that's kind of applied to everybody. I'll leave that there, so to return back to Lisa.
Thanks, Steve. So just really to say, the project is not yet complete. We're still working on it. But it has, I think, revealed to us that in order to talk about measuring effectiveness, we also really need to have a deep understanding about the company structures, as well as a lot of time and resource to actually carry out any measurement that would be meaningful. So I think corporate human rights harms are really difficult to measure in any event. They're industry-specific issues. They're narrative-based and qualitative in nature, unlike, for example, the gender pay gap reporting requirement. And the key that we've identified is really the need to have better infrastructure within the law that's built into the law to facilitate civil society monitoring, if that is what we want to do. It is too hands-off at the moment, I think, is what we're finding. And not just reporting on, not just reporting, but we actually probably need to push for more concrete retrospective reporting. So that means so could everyone just actually mute themselves? Thank you. We need to push for more concrete retrospective reporting. That's not just reporting on plans and possibilities and aspirations, but actual steps that have been taken in the past year. So I think we've used up maybe most of our allocated time, so I'll leave it there for now, but very happy to discuss further in the Q&A. So I'll hand it back to you, Lise. Thank you so much.
Thank you so much. That was very interesting, and I look forward to the discussion on that as well. So next I'll be handing over now to Andreas Rumkorf and Genevieve LeBaron. I understand Andreas will be doing the presentation, and then Genevieve will respond during the Q&A. Is that correct? I just wanted to say thank you so much for both being here. The study that you wrote together was one of the sort of leading references that we have been referring to in our work as well, and it's extremely interesting. So I look forward to hearing your presentation. Thank you so much.
That's very kind of you to say that, Lisa, and thank you very much for the kind introduction. So welcome everyone. Nice to see some of you again. Nice to meet some of you for the first time here. Speaking from Sheffield, where I've stayed. So I've said before, for the few who joined a few minutes earlier, and we might have a little appearance of my little boy later on, but actually it is a bit of an experiment. Whether or not Fireman Sam keeps him going for the next 15 minutes. So I've just started the DVD, so we shall see. So this is a joint paper I've written with Professor Genevieve LeBaron, who's Professor of Politics at Sheffield and Director of the Sheffield Institute of Political Economy. And we've been working for a number of years collaboratively, bringing together perspectives of law and political sciences, which we think is really valuable to look at it both ways. So obviously we do a thorough legal analysis, but it's very important to put supply chains and measuring how it works and what the companies are doing in an interdisciplinary context. So it's great to have the business side, academic side represented as well, because actually it's more like a tripartite approach that I very often think we need to look at the various angles from it. So with that in mind, we looked at two pieces of legislation, which feels like yesterday, but it's already a few years ago now, the Bribery Act and the Modern Slavery Act. I think we conducted our study mainly in 2016, so I'll say more about that in a minute. Got the paper published in 2017. So this is now calling for work to be done again to look at that kind of business action. So I'm trying to share my screen now as well, which worked earlier, just really for a few slides. And let me see whether or not that works. Apparently it does. Is that right? Do I get, yeah, got the thumbs up, that's great. So very quickly, what I'll be doing is talking a little bit about the background to what we're trying to look at with our joint political and legal perspective. Say a little about the research methods. Our findings reflect, as we've just done, about measuring effectiveness, which is really a tricky one that we all think about. And then if time allows, I'll just very quickly give a brief update on the German supply chain law initiative, because I've been asked about that. But I've seen that my friend Robert is also there from Berlin. So in the Q&A, he might be much more able to say a few things without wanting to force him now to do so. So I've obviously prepared, but it's great to see that Robert is there today as well, which was a nice surprise. So what we really did was we tried to think about it from the perspective of bringing together the interaction of public and private governance. So public governance interpreted here as the kind of state regulation, and then on the other hand, private governance as the company's private interactions, codes of conduct, what they do with their suppliers in their private dealings with each other. So really trying to measure how these two things fit together, because there's often an assumption of complementarity for so-called home state legislation, which is actually what we're looking at now when we look at all these different pieces of legislation from various northwestern, whatever, how you frame them in a politically correct way, European countries that are trying to address issues that happen within the global supply chain, particularly at the bottom of the global supply chain, for a number of reasons. So it's trying with home state regulation to address that issue. And obviously we've heard the French laws so far. I'll speak about the German initiative. We've got the UK transparency clause in the Modern Slavery Act. So it's like a developing framework. And we try to look at two different pieces there, one being corporate criminal law and the other one being a transparency regulation. So if you see those different pieces of regulation as part of a continuum with a soft end and a very strict end, then actually we'll look at them up at the very two ends of it. Although arguably The Bribery Act wasn't really designed with a supply chain in mind, but in terms of the regulatory tool, it is quite a strict one. So we wanted to see how they impact on corporate strategy and whether or not they differentially steer corporate behavior, thereby contributing to the thinking and the literature on public-private governance interaction. That was our background, how we came to this. And then we took an approach, which was a purely desk-based approach, where we looked at documents from 25 FTSE 100 companies about 4 years ago, got to say. So that was a year after Modern Slavery Act 2015, but companies were already required to publish statements, to issue statements. So we purposely selected companies that where we knew they have a global supply chain. I've got the companies on a different slide. And we analyzed for each company the company code of conduct, the supplier code of conduct, where available terms and conditions of purchase, at least what companies put on their website, looked at reports, and we also looked at anything else on the website that we could find. So we took an outside perspective. So the perspective was one where we thought we just measure or we just analyze what we can see. So we didn't speak to companies, we didn't send out a survey. We really just retrieved publicly available documents to gain a perspective on company behavior that way. So the companies we've chosen, as I've said, were intended to represent different sectors, different industries, and they all were also chosen purposely on the basis of that they put some information on their website, because without, we obviously couldn't be doing that kind of analysis.
Andreas?
And yes?
Andreas, sorry, I think you're sharing the wrong screen on your PowerPoint, because I think we can only see your title screen at the moment.
All right. Let me have a look. I just tried to do that finish again. Sorry about that. You can tell that we are a Google institution. So I'm just going to that again. Is that displaying now?
Perfect.
Great, perfect. Apologies for that. So I'm glad this hasn't happened in my lecture so far, he says. So what you see is really just an overview of the kind of different sectors that we've represented, the different businesses we've chosen from the different industry sectors. So energy, agriculture, pharmaceuticals, mining, retail, hotels, etc., etc. So we took that kind of approach by looking at different kinds of companies. What were the advantages of that? We were trying to see what's in the outside domain, in the perspective, taking a holistic view that goes beyond one or two individual companies. We tried to get that kind of overview. Companies couldn't really influence the answers by responding to surveys. I've been in another project a year afterwards where we tried to measure compliance of top 30 German companies, and we sent them a survey, and one after the other suddenly rejected the invitation to do that, which was with a business magazine. So it's been quite interesting actually to see what can happen when you start asking companies. So we left that out. Kind of limitations, it was done in 2016, so we haven't measured how things have evolved over time. As I've said, it probably really calls for looking at that again, because the Bribery Act was already a few years in place at that time. The Modern Slavery Act was still relatively fresh. As I have learned as a lawyer who is more usually doing this kind of legal analysis, it's called a plausibility probe. So we're not claiming any causation between the act and what we have seen, but it's like kind of trying to look at our intuition, which is really plainly that more stringent regulations, such as corporate criminal law, leads to stronger corporate reactions, to companies taking things more seriously in their private dealings, so in their private relationships with their suppliers, as opposed to weaker or softer forms of regulation, such as reflexive governance, so in the case of the Modern Slavery Act supply chain transparency clause. So we try to look at this intuition that we had. And as I've said, another possible limitations by not speaking to companies, we really only see what we see from the outside. So it's quite clear it's a transparency-based approach, but we can't really look inside. In terms of effectiveness as reflection, I mean, one question is compliance with the letter of the law, but there's also this thinking about how do we look at compliance with the spirit of the law. So these are the kind of aspects that are quite important. So the key findings, having looked at all these documents, and it's really interesting how much you can find on companies' websites when you really go beyond corporate reports. There's actually quite a lot that you can find and that you can interpret from different angles. So what we concluded is we found bribery has clearly appeared to have become a genuine compliance issue, and I'll say more about that in a minute in terms of specific aspects that we have identified. But it appeared to us to have become a genuine compliance issue, so a legal requirement companies taking seriously from a legal point of view. Companies use much more stringent language, which accords with that, when they are speaking about bribery, and that's in various aspects. And it's given also a much more prominent role within company reporting, both in terms of frequency and in terms of the quality of the reporting. And specific points, when we looked at these 25 companies that were quite interesting, in some aspects quite astonishing, is that, first of all, the language is much stricter, or has been much stricter for these 25 companies when they spoke about bribery. So there were notions of must not, anti, zero tolerance, so that kind of clear language, prohibitive. When it came to modern slavery or forced labor, it was more language of we strive to, we aim to. So it was much more kind of language that intends to achieve something, but is clearly not phrased in the same strict legal terms. When we looked at the quality of the reporting, 20 out of 25 companies had much more extensive reporting in their CSR, or increasingly it's called sustainability report. And that's measured by indications such as bribery got the prime slot. It may have been the first part. It got its own sector, its own section, its own part, much longer. Modern slavery, forced labor, often included in a section on human rights, as opposed to be given its own. And the use of the word bribery was much more frequent. I mean, in reporting terms, I have one report from Vodafone that referred to bribery 40 times and forced labor 3 times. So that was quite interesting as well. In the policies, that became even clearer when we looked at codes of conduct and supplier codes in particular. And sometimes these terms and conditions of purchase that we found, there are specific sections on bribery. There are specific policies, or at least due diligence is mentioned on the website in relation to bribery, and we couldn't find the same in relation to forced labor. And another example is GSK, for instance, terms and conditions of purchase. Both are quite strict in the wording about forced labor and bribery, but it has a whole Annex A in relation to bribery, and it also has a glossary of terms in relation to bribery. So it's just that's more serious dealing with it, and that's the same with stricter requirements in the codes of conduct as measured by language, by additional things, etc., etc. So frequency of words, language that we have found, policies that we have found, the use of the term due diligence, obviously due to the defense in the Bribery Act, clearly behind this, and the adequate procedures, so it was clearly influenced by that, but it was very interesting to find that and to see that. Just as a kind of reflection on this, as I've said, we don't prove a causal relationship. It's a few years ago, so things might have evolved over time. I would be surprised still if the policies have changed dramatically. I would be, maybe it's different because of that underlying legal framework. So in terms of our contribution, we think it does show that need for differential approach to home state legislation, to see that they are soft and they are stronger, and that stronger, I'm not saying law is the solution, because it's really a hybrid approach where you need to see things from various angles, including consumers and including lots of different other entities. But I think one part of the puzzle, and what this clearly shows, is strong regulation. So companies take it seriously and put into the compliance team rather than the CSR team. But on the other hand, we still grapple with this aspect of how do we ensure and achieve compliance with the spirit of the law rather than just the letter of the law. So this is clearly an issue. But what we have seen is where we looked at material that's out there, that there was a lot more serious material found about bribery, and that was in itself quite interesting. So far about that study. I'm happy to take questions afterwards, of course. I'm looking forward to ideas, of course, about maybe other ways how to measure and how to look at these things, because I think there's a lot of value in looking at documents that are out there. very briefly with a few remaining minutes, because I know time is nearly up. So there is, as you might have heard, a supply chain law initiative in Germany, which is dealing, as many other things now, with the COVID-19, because it really just gained speed at the start of the year. There was supposed to be a symposium in Berlin in March by civil society with lots of lawyers and experts to talk about aspects of it, and now it's come a little bit to a halt. If you can't read German, there is a blog online where people who would have spoken in March are now contributing to this. Where we are artists-led the coalition, that's still in place till 2021. Second is coalition contract agreements that they would look at this if companies are not voluntarily implementing human rights due diligence to a sufficient level. The recent study showed that I think only a fifth of the largest companies are doing it, according to what they said themselves. Ernst & Young conducted the study, interestingly. There are a few expert reports now. Robert, who's with us today, Robert Krabusch, is the author of leading experts reports on this. And we do have support by some ministries, which is really helpful from the two main parties, but others, especially Ministry of Business, Economic Affairs, is more skeptical. And civil society has started a campaign called Initiative for a German Supply Chain Law with its own website, etc., etc. So just in 1 minute, key features. What they will try is capture all large companies that have a seat in Germany or have a business presence there, which aligns with what we know from the Modern Slavery Act. It aims for a duty to undertake due diligence for human rights and environment for all business activities and business relations inside and outside of Germany. It's based on the UN guiding principles and OECD guidelines. In exercising their duty, companies should be obliged to take appropriate measures depending on size of the business, context, severity of human rights violations. There's a duty to document and report. That's seen as a core element. A failure to undertake the due diligence should lead to a penalty up to 10% of the annual turnover. There's the link to civil liability with torts is considered to be very important. And conflicts of law are also considered in terms of an overriding mandatory provision that German law is applicable. So it would enter a new avenue for German tort law through a violation of the duty here. There are lots of questions, of course, at the moment where the experts are writing about things such as proportionality, how to amend German tort law, how to measure an appropriate measure, what to say, whether or not we would need more regulations, because it's a catch-all for lots of different sectors. And we reference to internationally agreed human rights. And obviously that is a very broad phrase, especially for domestic law to measure. So there are lots of questions about that, but it's an interesting evolving discussion. And we will see, and obviously very happy to say a few more things about that in the question and answers as well. But just to say, this is an initiative at the moment. So it's not a legislative proposal that is fully out there. Civil society got one a few years ago, but there's not a proposal from the ministry at the moment. And apologies for slightly running over my time. So I've stopped the screen sharing. Thank you very much. I'm looking forward to answering questions later on. And Fireman Sam seems to have done his job really well, because I can still hear him in the background. Thank you.
Thank you so much, Andreas. That was really, really interesting. I'm sure there will be lots of questions, and I'm very impressed with your son and your abilities to have delivered a 15-minute presentation under the circumstances. So thank you so much. I will now hand over for our final presentation before we do the discussion. And this is Matthias Bauer and Hannah Derringer, who have worked with us on the study for the European Commission on due diligence through the supply chain. They are economists and have quite a lot of experience on measuring the effectiveness and impact of laws from a different area of the disciplinary area. So I thought it would be really helpful to also hear their views on what we are looking at today. So I will now hand over to you, I don't know, Hannah, Matthias, who would like to go first. Thank you so much.
Yeah, hi to everyone again. Thanks, Lisa, for this kind invitation to today's roundtable. My suggestion would be that I go ahead with a few minutes explaining what we did in the economic impact assessment on for firms, and then Hannah will step in and have a few more words about the impact on member states, EU member states, public authorities. The background is that we did the study together with Lisa and her team for the European Commission, assessing the economic impacts of the new proposal for a human rights due diligence, targeting mainly European companies that operate in the EU, but also in non-European countries. And what we did was conducting a cost-benefit analysis on the basis of 4 policy options that were developed by the European Commission. And we looked into the potential economic impacts in terms of costs accruing to businesses, but also potential benefits accruing to businesses. And we also discussed the potential impact on competition and competitiveness, and what is broadly known as innovation, basically innovation in business models, technologies, and technology-enabled business models, and so on and so forth. The analysis was generally informed by what I would call a rather broad literature review, where we looked into academic reports, we looked into existing impact assessment of similar regulations. We heard about the UK Bribery Act, but also the French Vigilance law. So we took into consideration literature on the potential and retrospective impact of these legislative acts. And the analysis was to a substantial part informed by a survey that we sent to stakeholders, mainly to businesses. And we received a great number of supplies from more than 300 companies, of which I think more than 100 were familiar with different aspects of human rights due diligence activities. At the same time, the responses were a bit skewed. 65% of all business respondents were very large companies with more than 1,000 employees. When we looked into the group of large and very large companies, but also the group of SMEs that responded to the survey, we also observed a relatively high variation in the indication of benefits and costs that were given by the respondents. And this is, I would say, mainly because the policy options developed by the Commission were stated in rather broad terms. The study was intended to be a preliminary study, and it did not aim to formulate a precise regulatory policy proposal. We basically looked into 4 policy options. One is sticking to the status quo. Policy option 2 was maintaining a set of regulatory guidelines. Then policy option 3 was about new reporting requirements, while policy option 4 would be the most comprehensive and also most, I would say, from a company perspective, prescriptive set of policies requiring mandatory due diligence throughout companies' value chains. And since these policy options were described in very broad terms, that resulted in varying expectation among the respondents, businesses, but also stakeholders from civil society, organizations, and governmental bodies, simply with regard to the legal obligations and companies' activities that would be required to comply with new due diligence obligations. We considered estimates from companies that already had experience with due diligence activities, but also companies that did not yet undertake due diligence activities. And you look into the study, you find cost estimates, for example, provided for large companies, but also SMEs, and we also come up with a ballpark number for the EU 28, including the United Kingdom as a whole. Our estimations were based on 2 indicators, person day estimates indicated by companies regarding the conduct of business, of impact assessment. For example, tracking the effectiveness of actions taken by the companies. We looked into person-day requirements for training activities for staff. We looked into requirements for legal actions, for example, incorporating standards into contracts, but also took into consideration the management of external parties like auditors, external investigators, and so on and so forth. And then we added additional costs, basically overhead costs, and took monetary numbers approximating these staff requirements to extrapolate these data on the basis of available statistics for the number of companies per industry and size class. For example, I don't go into the details regarding the numbers that we arrived at, but for large companies and SMEs, we provide numbers reflecting the cost impact, the annual cost impact for different policy options, starting with new voluntary guidelines up to the requirement to conduct mandatory due diligence throughout the value chains. And so, for example, for large companies with revenue exceeding 50 billion euros, we arrive at additional annual costs of about 4.5 million euro. For a large company with 1 billion euro in annual turnover, the number is substantially lower, at about 100,000 euros. And then we also plot numbers for small and medium-sized companies. For example, a small medium-sized company with a revenue exceeding 50 million euro would be exposed to an annual cost burden of additional 70,000 euro, approximately one full-time employee in a Western European Union member state, I would say. When we look into the benefits, there are many potential benefits that can result from due diligence regulations. We've heard about a number of benefits from previous speakers. In the literature, we read a lot about potential positive impact on financial and stock market performance. For example, the lower cost of capital. There's a wide base of evidence regarding the positive impact on brand image and reputation, but also attractiveness of companies that stick to certain rules for employees, basically the positive impact on human resources. And last but not least, a positive impact on the operational efficiency of companies across their value chains. At the same time, we should admit that it is generally difficult to isolate these effects from each other, to isolate the effect of one responsible business conduct measure from another. When we look into the survey, I'd like to outline a few potential benefits that were indicated for policy option. For the most prescriptive policy option, mandatory due diligence throughout companies' value chains. And here, respondents mainly expect benefits in the form of greater leverage over suppliers, especially non-EU suppliers, provided by a non-negotiable standard, and greater legal certainty, followed by greater supply chain certainty and lower operational risks. At the same time, the expected benefits depend on the coverage of companies and the enforceability required. Another disclaimer is that generally, the more companies the regulations would apply to, the smaller would be the potential relative economic gain from, for example, enhanced brand image and reputation. So the relative gain, or the absolute gain, would be much higher for a large company whose revenues increase by 10%, for example, compared to a small company whose revenues increase by 10% because of enhanced reputation. And finally, we had a brief analysis on competitiveness innovation, similar to the assessment of costs and particularly benefits. The impact on competition, competitiveness in innovation is difficult to assess ex ante. There were many concerns shared by companies regarding cost competitiveness. EU companies might be at a relative disadvantage compared to companies, for example, non-EU companies, Chinese companies, Russian companies that do not have to comply with any form of mandatory due diligence regulation. And therefore, some internationally operating companies may even have to withdraw from markets that are relatively risky with regard to human rights and environmental risks, and countries that for which it's difficult or expensive to monitor the reality regarding human rights infringements and so on and so forth, and high mitigation costs respectively. And EU companies might be replaced by companies that do not have to comply with these due diligence regulations, even though some of these companies pose a higher risk of human rights infringement than EU-based companies. My policy recommendation for policymakers, European policymakers, if the European Commission decides to go ahead with such legislation, would be that the Commission should at least closely monitor EU trade and EU investment after the implementation, particularly the development of EU businesses' market shares vis-à-vis companies from other jurisdictions, which are known to be much less eager to show respect for the fundamental principles of human rights. So I would leave it with that, and I would pass on to Hannah for the second part of this presentation. Thanks.
Thank you, Matthias. I would just briefly add a few things. So Matthias mainly described the assessment of the economic impacts of the proposed legislation, but in the impact assessment, we also discussed potential impacts also on other policy areas. So we also looked at social impacts, on environmental impacts on public authorities, and impacts on human rights. So human rights and environmental impacts were done by two other colleagues from LSE Consulting, and I looked at impacts on public authorities and potential social impacts. So as Matthias said, the assessment was mainly based on a literature review, so we were mainly using previous impact assessments, or ideally ex post assessments of similar regulations, trying to find aspects of legislation which is similar to the one that was proposed by the European Commission, in order to draw then some conclusions. And we had the survey, but this was very general questions about expected impacts from respondents on social areas, and then naming some social areas where they would expect positive, negative, or neutral impacts. So the difficulty for social impacts in public authorities is that there is no quantitative data to rely on, but this was mainly a qualitative discussion of existing literature, and the main findings were very general, as you could expect from logical deductions, that social impacts would be expected to be highest when the proposed law would be most concrete and most mandatory in its definition. And for public authorities, costs would be expected to be highest when the law would be accompanied by a mandatory mechanism and an oversight mechanism by the state. So those were very general conclusions, but maybe that also leads to an overall conclusion for those impact assessments, that it's very difficult to assess proposed regulation which is not very well defined. In order to assess an impact of something, it would need to be as concrete as possible in order to then draw conclusions, but also to find potential data to rely on. But the proposed legislation is still very general in its language and in the options, and it's not very clear how options would then be implemented in the end. And the other main point, but I think that has also come through at the other presentations, is always the lack of data. Matthias used the data from the survey, but often the data contains confidential information from firms, and you need to find firms which are willing to share that type of information. And if you don't have enough quantitative data, you can't use any other quantitative methods, and you need to rely on case studies or other descriptive material from previous literature review. So yeah, that was just my additions from my side, and happy to respond to any questions if there are any at the end. Thank you very much.
Thank you so much, Matthias and Hannah, for that.